Hey everyone, it's Rob Ryder. Today is Saturday, July 3rd, 2021, and faith is Esquire's Achilles heel. And it truly is, right? Full faith and credit of the truth shall set you free. We just need to figure out how we implement it. And, when I worked at a nuclear power plant, it was always said that, well, first you plan the work and then you work the plan. So right now I'm still in the plan and the work. I don't really have the plan figured out. I'm just trying to put it in my head, and because this is a big subject with lots of little tentacles going on, where I have to grab information from all sorts of places. It's way too much for me to keep in my head from beginning to end. So this is just kind of an outline of where I'm headed with this. But it's all based on full faith and credit, and how we use that to our advantage over Esquires. Because as it turns out, right, if you're in a civil case of some kind, now think about this, the Esquire, for the other party, they've really not ever served you. They've only pretended to. And if you know that you haven't been served, well, then there's certain things that you could do. Right? So more on that in just a second. But under the Article 4 of the Constitution, in Section 1, it says that full faith and credit shall be given in each state to the public acts, records, and judicial proceedings of every other state, and that Congress may by general law prescribe the manner in which such acts, records, or proceedings shall be proved and effective thereof. Right? So, certain things like public acts, records, and judicial proceedings can have full faith and credit. So, right, I'm Staff Sergeant Robert Allen Bertluski, United States Army veteran, and I'm 62 years old. I'm still a Staff Sergeant. I never got a release order, so I'm not letting them take away my SSG and try to stick me with an MR for Mister. You all know that a Mister, right, is the fucking lackey of an Esquire. In the English system of gentlemen, there's two levels of gentlemen, which that's not a title of nobility. They're crown agents. And you have the Esquire above the Mister. So you don't want to be a Mister. Or a Ms. Right? So, but for our purposes, you can call me Rob Ryder. Now, what's going on here? Oh, and my email address. Right? If you really want to contact me and have me try to answer something, you got to send it to courtofrecord@aol.com. Right? Just as an email. But at the end of the day, I just get too much stuff. Sometimes I can't answer everything. And I'm really looking for an answer. I'm not looking to explain something I said 10 years ago in a fucking video, right? That's not what I'm interested in. You may be interested in it, but I'm not. Right? So you have to bear with me. I'm trying to find a solution based on what I did 10 years ago and all that time up until now. Right? Trying to tie all these things together, and well, that's kind of where we are now, starting to go into the past and pull things back forward. So in my last video, which was hang on a second here, which was Lord's Prayer and your hour of testing, day in court, and in which I was explaining that I'd gotten this email from a guy that said he had said the Lord's Prayer in court, and basically he was told to leave. Now, when I did the video, because in Indiana you can go look for court cases, and he gave me the court case number, and I went to look. I couldn't find it on there. Right? But maybe I put his name in wrong or whatever the first time, because I went back again and found it afterwards. Right? So there is a court case still in there, but what they did in the court case is interesting in its own, and it kind of led to a few other things that I'll be talking about in this video. Which was, after I had done that, so basically, before I go on, so really what I told the guy right here, right, I had talked to Rob before going to discuss my strategy, and before we ended, Rob suggested that I state the Lord's Prayer at least 3 times before entering the bar. Right? And that was based on a story I had heard, in my years of doing this, that somebody had told me that there was a kid who had gone to traffic court, and he had all sorts of people give him advice what he should do and what he should say and so forth. And like a 17-year-old kid or something, I think, young kid. And so, it's his turn up at bat, and eventually the judge says to him, well, do you have anything to say for yourself? Right? It's just a traffic case. I talk to the prosecutor, and I'm going to talk to the defendant. And the kid just bowed his head and said the Lord's Prayer. And when he got done, the judge said, leave my court, never come back. And, that's very good. Now, what I had added to that was the fact that, you can test a spirit up to 3 times. Right? So you should say it at least 3 times. And I had proven this, not with the Lord's Prayer, but by having somebody accept a judge's oath. Where the first time they act like they don't hear you, and then they try to interrupt you. But if you say it 3 times, they'll agree that you've accepted their oath. Now what do you do with it that you've accepted their oath? That's the part that seems to be missing sometimes is, that isn't the complete answer, but you finally got the court into the proper jurisdiction. But to try to offer this stuff to people as, what to do in court, that's not really what they want to hear. They want to have you write them a piece of paper to put in a court case. Right? And I've just learned over time, well, these really aren't courts. They're at least not the courts of the state because none of the people in there have proper oath of office. So there should be something else we should be doing. Anyway, so that was all that, right? Blah, 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 blah. And so I'm going to show this guy's court case in a minute. But I was going to go back then and make a change on the video, say, hey, there's actually this thing in there. And I happened to see this entry, right, that said, Rob Ryder, I have an update for you. You helped me with the foreclosure in 2019. Yeah, I know. That's Jackie. Yes, Jackie, Lake County, Florida. The foreclosure was canceled. I looked in public record a few days ago, and there is an $18K lien release, $35K mortgage release. General affidavits were filed with something I don't remember filing, with no cross-party property taxes are being paid. Now, if you look at the court case, it doesn't show that. It shows that the case is still open. But you read what she's saying here is in the public record, which is more like the county recorder's office. Now we're not in the court, right? These things have happened. The lien's been released, mortgage been released, general affidavits, yada, 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 yada. Okay, so that's very interesting. And we'll look at that also. But that wasn't all. In fact, I actually had this one before I got the call about... hang on, I got to make that thing there go away. Before I actually got the one about the prayer, right? But these have all happened the last 3 weeks, and it's like I've been pondering this one since I had first gotten it, which was way back in 2013. I recorded this document, which is a writ of mandamus. We'll look at that too. I copied your outline for a writ of mandamus and added and changed it. I once got a court summons to answer credit card debt in Drake County Court, Greenville, Ohio. I mailed the court this writ of mandamus prior to arriving to the scheduled court date. When I arrived at court, the bailiff blocked me at the courtroom door and pushed a dismissal into my chest as if he was very angry. All right, so he filed a copy. Let me see. He recorded a writ of mandamus, right? Then he took that recorded writ of mandamus and he sent it to this court that he had been summoned to, Drake County, Greenville, Ohio. I don't know who he sent it to exactly. I'll get that from him. All right. Did he send it to the clerk? Did he send it to, Who was it? Okay. I mailed the court this writ of mandamus prior to arriving at the scheduled court date. And when he got to court, the bailiff blocked him at the courtroom door and pushed a dismissal into his chest. Now, he did this in 2013. He's telling me this year. I mean, if I had known this in 2013, maybe I could have used it then. But I figure God has a reason for, bringing things to light at the right time. And I'm sure that it's because I wouldn't have known what to do with it back then. But I'm getting a much better idea these days because of all the, research in between. So his question was, proper for man to issue a writ of mandamus. Well, it's proper for a court to issue a writ of mandamus. So if a man could be a court, it would be proper. Or did this work for me because I merely recorded a public notice and recorded it in the county recorders? Hey, you know what that would be? That would be making a public record, right? Just like this. That's a record. There you go. Scott saying the Lord's Prayer in court, well, that's a public act, right? That's a man's act in a public, in a public hearing. So yeah, that gets full faith and credit. A record gets full faith and credit. And what was the other thing that gets full faith and credit? Oh, judicial proceedings of every other state. So now that, little phrase there in the Constitution, it's been expanded, and they got the annotated Constitution. We'll look at that just a second to see what that could mean that we could use for our benefit. But you can see where I'm going with this, right? That certain things have made shit happen in court cases that, hadn't happened before. So one lady at court told me I was wrong, that we must petition the court for a writ of mandamus. But again, if you're the court, you can issue the writ of mandamus, right? And what would make it stick, right, is to have it recorded. But I think what was missing to make it a judicial proceeding, right, more like a foreign judgment, was simply the fact that you would have it attested to before a notary, and then go to the notary and get their certificate of authority from here you go to the county clerk, say I need a certificate of authority for the notary. And all it does is prove the notary is who they say they are. And that document has got the court seal of the county court on it. Well, now you got a judicial proceeding. So I want to talk about all those things, without a lot of detail or even try to tell you how it's going to work. I'm just pointing them all out, right? That's what this is about, is pointing out all the different little pieces we had to play with and see if we can build something out of it. So faith is an Esquire's Achilles heel. Let's try to use it against them. Or let's try to use it for us. We're not trying to against them. We're using it for us, right? Because, faith will set you free, or truth will set you free. Okay, hang on a second. Okay, so this was the case I was talking about in the Lord's Prayer video, right? So Scott Rhodes and a Newton Circuit Court, right? Right, 56C 01 1106. Well, this 1106, this means this started in 2011, which is probably why I didn't see it. He was telling me about something in 2018, and I wasn't realizing this went back to 2011. But here it is, and it's in the, this is getting the records right off of the state website. And he had said that whatever happened in April, right, which is on April 12th. Right, well, here's something for April 11th, but there's no entry for April 12th, like nothing happened. And but the total e-filed amount $28 assessed. We'll have to look at that in just a second too, see what that's about. But and then it went to 5/18, like this case kept going on. Well, Scott has said that he only went in April and he was told to leave, so all the rest of the stuff happened then. And eventually we get down here to where on order of proceeding, supplementary hearing, plaintiff appears by attorney, defendant appears in person without attorney. Well, remember that the defendant really isn't Scott and his full legal name. It's some freaking, abomination of his name. So it's a John Doe, basically, right? So if this is true and Scott didn't go back, then they had somebody appear and say that he was, the defendant. Mr. Fictitious name, Mr. Middle Initial, whoever it is. But it's not you because you have a full legal name. You were never the defendant. Right? These cases aren't in personam. They're not being done against the person in their full legal name, so it's not an in personam case. It has to be some kind of in rem case. My point is that it went on. Scott hasn't heard any more about it, and there's been nothing that happened. Now, they still show that he owes this amount of money, right? But if you go down here, right, this thing, there was an assessment of $177 back in 2011, and they didn't pay the whole thing, right? So what was the $28 for? Why wasn't it paid in 2011 when the payment was assessed? They paid the first $149, didn't pay the whole amount. Well, I think that the difference here is this is the service. It has to do with having them served, right? And so there wasn't proper service done. So they did something here. He said it happened in April, but they're not showing here. But they did do a total e-file amount, $28. I don't know what that would have been for. Why wasn't it paid? Right? Is this a new fee? But why wasn't the original $28 paid in 2011? Strange. All right, now hang on here. All right, so remember, said. So, anyways, he started doing these prayers. Right, he got 2/3 the way through the third prayer, and the judge said, "Go sit down or get out of here." He wasn't really sure which one. Right. Now, all I would say now is, well, don't stop. Right, you're going that far. Go all the way to the end. Give the man his 3 witnesses. Right. So, and then go ahead and leave. Then all that was said, he told the prosecutor or prosecution that they could refile if they wanted to. So there you are, right? And crickets for him. But according to the record, something was still going on in the background that Scott wasn't really part of. Hang on, I got a plane going over, or a helicopter. Okay, so and now this next case, then, this is a foreclosure case that was going on in Florida. So if you got a foreclosure going on, pay attention to this, because, this is what's going on. Now, where is all this stuff? I got so many windows. Yeah, so if you go to, if you want to follow this stuff yourself and see what I'm looking at, right, go to Lake County Clerk, Florida. Google that. I'm sure you'll find a page, and you'll find a place where you've got to push a button to access the court records. And then the court case number is 35-2019-CA-001306. That's enough to find this case, where it shows that it's still open, right? And it has the party name, right? This is the plaintiff now, United States of America, acting through Rural Housing Service or successor agency, United States Department of Agriculture. Now, you really need, stop and think about this for a minute. If you owed the United States money, they wouldn't be coming to a state court to get it. They have their own courts. They're called the federal courts, right? They would have charged you in a federal court. So it isn't the United States of America. The plaintiff is his whole freaking name. It's something that was made up by an attorney, by an Esquire, to put in the place of a plaintiff. Because, they're not going to serve you anyways. This is all being done like a Ricky Lake show. All smoke and mirrors. Right? Lots of backstabbing, all sorts of things going on in the back room. But, this is what they call a court case. And in this case, it's got like 107 entries altogether, right? But a lot of these happen after, Jackie had anything to do with it. So if you went to the beginning, you would see that it looks like they put in summonses, right? Summons to be issued by the clerk. Summons issued to clerk of circuit court. So I don't know why they did summonses to be issued and then summonses again, right? But they got 2 sets of summonses in here. And let me find them copies real quick. Okay, and so here's the summons they put in for Jackie, right? Summons personal service on a natural person. Or actually unknown spouse of Jacqueline V. Veazey, a.k.a. Jacqueline Victoria Veazey, a.k.a. Jacqueline. This is how they describe, Jacqueline Victoria Veazey, which is about her full legal name, but I think they spelled Jacqueline wrong. Even they got that wrong, right? All done intentionally. They don't really want to charge you. They're using all these fictitious names. But, this is who this particular defendant is, unknown spouse of da 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 da. So they were all like this, right? And then they had this little statement here, and they got a seal here, because there's a bunch of people that got served in this case. They like 7 or 8 different services or summonses that went out. So the question is, well, is this really a summons? I know it says it's a summons, but is it a summons? Well, let's take a look, because this is the closest example they have in Florida to what that thing is, right? In the Circuit Court of, that right next to it here. All right, so if we go to the top and we look, we got in the Circuit Court of 5th Judicial Circuit, is that completely correct? Yeah, pretty much. Fill in the blanks, got case number, division number, petitioner, respondent, summons for personal service of an individual. This says for a natural person, see? So it isn't exactly the same. They didn't use the same title. Right? And this is the one the state has. But as you'll see in here, you got to put full legal name of the party, right? And address, location for service, and then put an address in here. Well, that shit isn't in this thing. Right? This is not a full legal name of a party. And in this important part here, see, remember it says a phone call, right before that should have been where the line was in to put an address. Attached complaint petition with the clerk of the circuit court located at some address. Well, that shit isn't in here. Attached complaint in this court. Right? So they changed the wording. They don't have the line. They're simulating that this is a summons. This may be what they got the clerk to put a seal on. But by the law, it's not, it doesn't meet the criteria for that court. Okay, and so actually this style here is supposed to be used for family court. This is the one you're supposed to use for, in the circuit court or circuit county court of the, whatever hers would be 5th, judicial circuit, in and for whatever county it is, right? Civil action, got the names, got the case number. It should be like this. State of Florida, each sheriff of the state, you are commanded to serve this summons and a copy of the complaint or petition in this action on defendant, da 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 da. Well, that isn't what's been filed, right? And this is, according to Florida, this is the one you're supposed to use for civil actions. It's covered by Florida Civil Procedure. Form 1.902A, right? So this isn't what they used. And the proof of all this that it was wrong, and this is what we're going to get to now. We go look at the case, what happened in her case. I don't know if I'll exactly show you where it says it, but basically, if once you've been summoned, you got 20 days to answer, right? So the things that was happening were like back in June of 2019, and we're all the way up here to January of 2020. And, right, and number 92, Jackie put in an answer. Well, that should be too late according to the rules. You have to answer within 21 days or 20 days, whatever the hell it is. Yeah, I had to be in summons. Yet she put in an answer. Right, so we'll look at what she put in for an answer here. I find that thing again. Defendant answer. All right, defendant's answer to the complaint. So, 7 months after, she's putting in an answer. She put in the stuff about the OID and so forth and so on and yada, 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 and all these different points. Blah, 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 blah. This was her answer. Right? Well, if it had been too late for this to have been put in, that would have been the answer back to this document by the plaintiff. So hang on a second. So what happens later at about, I think this is number 101, right? So some other documents went in. There's also all sorts of things going into this case. But at 101, motion to strike answer and affirmative defenses. So there you are, right? Now, it's well settled fact. Florida pleading rules, counsel recognize elements or cause action, determine whether it can develop facts necessary support. Affirmative defense or claim must be clearly and consistently set. Essential facts, yada, yada, yada. All these reasons to do it without ever saying, hey, it's way too late for this, Judge. Right? So this is 101. I can't sit here and read all these things. It'd just take too long. It's not my intention to go through everything in this case. I'm just pointing out that Jackie was able to put an answer in months afterwards, and they're acting like they have to answer it. Well, we can go look at some rules of civil procedure and see why that would be in just a second, but a couple more things to show you here. So the next thing they put in then was, this again from the plaintiff, they wanted first request for admissions. Now this is, making people admit to things, one of the steps you can do as discovery. Right? But they wanted Jacqueline V. Veazey to answer. Right? Well, there is no Jacqueline V. Veazey. This whole thing is the defendant again. Right? So everything up to the et al. If it was just Jacqueline V. Veazey, then it would say et al. After that. But then it said Jacqueline V. Veazey, a.k.a. Jacqueline Victoria Veazey, a.k.a. Jacqueline Veazey, et al. Right? So all these other words here have to do with Jacqueline. That's the name of this particular defendant, which, of course, is nobody's name, right? That's the point. That isn't anybody's name. So it must be an in rem case because it's not in persona. They're not using somebody's name. And the reason I say that, in an in rem case, you could bring up the fact that they didn't verify their complaint. Right? But anyways, but she didn't have to answer this. Right? There was a couple more here. I wanted you to notice at the bottom of these things, right, that they have this EXL Legal P LLC company with some scribbles, and it says Josephine Dian. Right? But you get to the last one that they've entered so far. It's notice of attorney of record and directions to the clerk to update attorney information. Right? Please be advised that the law firm that we just looked at is the law firm representing the plaintiff. Right? The plaintiff is not the United States of America, the country. The plaintiff is his long-ass freaking nonsensical statement of words put together to say, well, this is the plaintiff. And that thing's a plaintiff's attorneys are Peter Lanning, Esquire, and Andrew L. Fivecoat, ESQ. Now, why is he only an ESQ and not Esquire? That's interesting why they did that. But they're the counsel of record. Well, they should have put this in at the beginning of the case. Right? But they never put in that they were, notice of who's the attorneys of record. So like in a federal case, I see it quite often. I'm looking at those that they put in some document saying that, an appearance, right? The attorney needs to make an appearance. So now they change these names to these are the Esquires, right? But if you look at this other one, right, that isn't the guy who was signed. It was Joseph N. Dian. Well, now these guys are. Well, let me make sure I'm in the right one. No, this one over here. And when you go to the bottom, right, Peter E. Lanning has his name. Didn't have that before. Okay, so again, this is a court case, but what Jackie had said was that, where it makes a difference is in the records, right? Because wherever there's a lien, that's been released, the mortgage has been released, the general affidavits was filed with something I don't remember filing, with no cross-party, property taxes are being paid. So I'll get all this from Jackie and I'll show it in the next video. But point is, hey, something happened. And it happened because Jackie put in an answer. Right? Because he put in an answer because she'd never been served. right? Was still within 21 days of being served because she hadn't been served. And where? So let's just really quick look at some. I copied these out of the Federal Rules of Civil Procedure because it's a little bit easier to see, right? But you're going to commence an action. You got to file a complaint, right? Then you have a summons, and the summons, right? Content summons must name the court, be directed to the defendant, state the name and address of the plaintiff, state the time in which the defendant must appear to defend, notify the defendant of failure to appear, be signed by the clerk, and bear the court seal. Right? So that's what it would take for it to be a proper, in federal court, for it to be a proper summons. And then what happens? And, so we just talked about up here, we're doing this to send a complaint. Well, that's called a pleading, right? There's various kinds of pleadings. Complaint being one, the answer to the complaint being another, answer to the counterclaim being one, answer to the cross-claim, third-party complaint, answer to third-party complaint, if the court orders one, a reply to an answer. Okay, so who must file? This had to do with non-government disclosures. This was for federal court. So that's something that should have been filed. If you're in a federal court case, right, and it's not the federal government coming after you, did they file a disclosure statement? So general rules of pleading. Well, this is pleading for relief. Yeah, but affirmative defenses. This is what we're getting to. Okay, so now somebody's supposedly filed a complaint against you. Well, you can have affirmative defenses. In responding to a pleading, a party must affirmatively state any avoidance or affirmative defense, including, right, accord of satisfaction, arbitration, assumption of risk, contributory negligence, duress, estoppel, failure of consideration, fraud, or illegality. Right, latches. So all these things here are affirmative defenses that you could have used for your answer in responding to a pleading. So if you're responding to a pleading, it was a responsive pleading. And by you responding, then you have to have stated these as part of your answer. But then it goes on to say if you're pleading special matters, except when required to show the court has jurisdiction, a pleading may not allege a court's capacity to be sued, a party's authority to sue or be sued in a representative capacity, legal existence of organization, association with the persons that is made a party. So the plaintiff in a foreclosure really isn't the bank, right? They're not using the proper name of the bank. I mean, in this case, we're looking at this thing that had it's like a rural home loan type of thing, right? But normally you see you would think it's a commercial bank's name that's being used as the plaintiff. But if you look at the name and you take it just the way you see it on the paperwork and go check your state on the state Secretary of State's website to see if they have authority to do business in the state, the name that's on the document doesn't have any authority. So they don't have a capacity to sue or be sued. Right? So, so an answer, again, that's a pleading, right? Now you'd be pleading the fact that, the party doesn't have a capacity to sue or be sued. The legal existence of an organization, association of persons that is made a party, right? Do they exist or not? Raising those issues, to raise any of these issues, a party must do so by specific denial, which must state any supporting facts that are peculiar within the party's knowledge. So you claim that the party doesn't have a capacity to be sued because you checked the state's website and here's a page that says they don't have any authority, right? They're not listed in the state as a business that can do business in the state. Because the name they put on your complaint isn't the proper name of a bank. Now, there could be a proper name of a bank in the state's website. In fact, there will be, right? That can do business, but it's not the name that's on your complaint. And we're just talking about names on the complaint. Right? So the party named as plaintiff in this complaint doesn't have authority to do business in the state. Therefore, they don't have a capacity to sue or be sued. That would be your defense. You don't need any more. But you could say it's fraud or mistake. Right? That it was done intentionally, which it is being done intentionally. Right? So quit thinking the bank is foreclosing on you. It's not the bank. It's an attorney using the name looks like a bank that's going to put this scheme together with smoke and mirrors and pretend that he served you and see if he can get judgment without ever serving you. Now, how all that works, I don't know, but this is what they're doing. Right? What other special matters? We could plead special damages. If an item of special damage is claimed, it must be specifically stated. Now, a damage is a word they use in general liability insurance, right? To get paid, you get paid damages. And one of the damages to be paid is for malicious prosecution, right? So you could say it's a malicious prosecution, right? And you want to be compensated for your damages for the occurrence of the malicious prosecution. In fact, let me show you that real quick. If you've never seen them, back in like March of 2020, just before the COVID shit hit, I was doing these videos on liability insurance. And the first one, like 3 in a row, was called Read the Back of the Can. Right? And so if you go to my website, Rob Ryder, ROBBB, 3 B's, Ryder, and on YouTube, right, and you search by upload date for videos, you should go back and you'll find one that says Read the Back of the Can, January 2020 to March 2020, in that time frame. And again, there's 2 or 3 of them that go together at the same time. But in there, I'm talking about, well, here's the general liability form, right? So this is, a legal document, and this is what comes with the case then, or with your general liability insurance. And if you go down to this, where is that here? All right, we talk about what an occurrence means. Means accident, including continuous repeated exposure to substantially the same general harmful conditions. Well, what does personal and advertising injury mean? Including consequential body injury arising out of one or more of the following offenses. Right? False arrest, detention, imprisonment, malicious prosecution, wrongful eviction, oral or written publication in the manner of materials that slanders or libels a person, organization, or disparages a person's, organization's goods, products, or services. You can read them for yourself, right? So this is what I'm saying. You're going to claim that it was a personal advertising injury because you're the victim of a malicious prosecution. And their, general liability insurance has a pay per occurrence of $1 million. So you're claiming $1 million in damages. That's the way I would look at it, right? That's, again, I'm not telling anybody to do this. I'm just talking out loud. As far as doing it, we'll get to that, soon enough. But these are just the reasons why. So hang on again. Okay. All right. Admiralty or maritime claim. Everybody wants to say that, we're involved in admiralty and maritime claims. It's admiralty court. Did you know that actually admiralty and maritime is Article 3 court jurisdiction? It says so in the freaking Constitution. All right. So if you're in an admiralty case, well, then you must be in an Article 3 court. Well, the thing about admiralty or maritime is they have to verify their complaint, and nobody ever verifies the complaint. So that's another defense, all right? The complainant didn't verify his complaint. It's a malicious prosecution. It's fraud, for these particular. It's fraud because the party that's listed as the plaintiff doesn't have a capacity to sue or be sued. You could just string together so many things that are wrong, but really you just need one. Then you got to have some way to support it. Right? Signing. So who has to sign? Sanctions. Right? If after notice of reasonable opportunity to respond, the court determines that Rule B, 11B, has been violated. What was 11B? Representation to the court. By representing to the court a pleading, written motion, or other paper Whether by signing, filing, submitting, or later advocating it, an attorney or represented party certifies to the best of the person's knowledge, information, or belief formed after inquiry reasonable circumstances. It's not being presented in any improper purpose, such to harass, cause unnecessary delay, and needlessly increase the cost of litigation. The claims, defenses, or other legal contents are warranted by existing law. So basically, if you can say they violate one of these, you can ask for a motion for sanctions, which is damages. A motion for sanctions must be made separately from any other motion and must describe the specific conduct that alleged violates 11B. That'd be simple enough. Right? So that's one way you can get it, or on the court's initiative. The court may order an attorney law firm to show cause why. Right? So what they're telling you is if you want to do this, you need to apply for an order to show cause. Right? It's an application for an order to show cause. Why sanctions shouldn't be enforced against the party for the following reason, right? Whatever your reason is. Right? Requires from our order imposing sanctions must describe the sanctioned conduct and explain the basis for the sanction. Okay, limitation monetary. Court must not impose monetary sanctions against a represented party for violating 11B2 or on its own unless it issued the show cause order under 11.3C3 before voluntary dismissal or settlement of claims. So you need to have issued a show cause order under Rule 11C3. Requirements for an order. An order imposing sanctions must describe the sanctioned conduct. Okay, so I don't want to get too deep into all this. It's just too much stuff, right? But how to present defenses. Now, this is under, we get to 12 yet? Rule 12, yeah. Defenses and objections. Because this is what, you're doing basically. You're defending yourself. Defendant must serve an answer within 21 days of being served with a summons and complaint. Well, apparently that didn't happen in Jackie's case because she sent it 6 months later and, they acted like it was her affirmative defenses. Right? That's how the plaintiff's attorney responded to it, as if he was responding to affirmative defenses. So how to present the defenses? Right? For every defense to a claim for relief in a pleading must be asserted in the response of pleading. Right? That would be the answer to the complaint if one is required. But a party may assert the following defenses by motion. Right? Lack of subject matter jurisdiction, lack of personal jurisdiction, improper venue, insufficient process, insufficient service. Right? All of these things are reasons that you could, by motion, without answering, ask to present your defense. Okay, so like I said, there's a lot to cover in this little subject area, and I don't have time to get into too deeply. I'm just, like in my own head, I'm trying to put it all in order to go do something. So, hang on, we'll look at a few more things. Yeah, so I guess, I'm trying to say, well, in Jackie's case, basically, she got full faith and credit, right, because of the judicial proceedings that she did. She put in an answer or affirmative defenses to a claim that had been made to somebody in a court that's in the state. It may not be a state court, but it's a court in the state. I got to find that too. Hang on. Okay, so if you Google on like full faith and credit proof, you may find this full faith and credit miscellany, right, which is basically the annotations that are on the Constitution, right? And so this is this section we're talking about. And it says the rule of 28 U.S.C. subsection 1738 and 1739 pertains not merely to recognition by state courts of the records and judicial proceedings of courts of sister states, but to recognition by every court within the United States, including recognition of the records of proceedings of courts of any territory or of any country subject to the jurisdiction of the United States. The federal courts are bound to give the judgment on the state courts the same faith and credit that the courts of one state are bound to give the judgments of the courts of a sister state. The power described, the power to prescribe the effect to be given to the judicial proceedings of courts of the United States is conferred by other provisions of the Constitution, such as those declared the extent of judicial power of the United States, which authorize all legislation necessary and proper for executing the powers vested in the Constitution of the government of the United States, and which declare the supremacy of the authority of the national government, which is not the federal government. Now we're talking national government, because they use federal government in other places, and these when they're talking about this kind of stuff. So national government. See, I think we the people are the national government. We're not the federal government. We're the national government, right? That we're a court. And so we have our court in the United States, and we're subject to the United States because we're in the United States. So, if we lied, they can take us to the United States court. But, that we should be able to do our own judicial proceeding. Just, had better be right. So, and then it talked about this, write this down, 28 U.S.C., 1738 and 1739. You can go find them easy enough, right? Google 28 USC 1738, and you'll find this govinfo at .gov. I like those the best because you can pull this off. And it talks about state and territorial statutes and judicial proceedings, full faith and credit. And then 1739, state and territorial non-judicial records, full faith and credit. Right? All non-judicial records and books kept in any public office of any state, territory, possession of the United States, or copies thereof shall be proved and admitted into any court office, any other state, territory, possession, by attestation of the custodian of such record or book, and the seal of his office affixed, if there be a seal, together with a certificate of a judge of a court of record of the county, parish, district, so you got to authenticate it. Anyways, they're talking about, a library record. At the end of the day, that's all that is, because there's a law in Michigan that says you can use library record as evidence. Right? Library record. So a copy of a record, just about what we read, book, paper, so forth, if accompanied by a sworn statement of the librarian or other person in charge of the record, copy is true, copy of the original in his or her custody is admissible as evidence in a court or proceeding. Right? So, this is where, you should be able to go down to the local library and say, I need a copy of 4 U.S.C. 101, the law that says that, these officers had to have a particular oath of office to be a state officer. And, or whatever it is you need to put into your court case. So, but it could be a book. It doesn't have to be a record. It could be the whole book. Whatever it is you want to use, newspaper, whatever your evidence is. This is how you get evidence to put into a court case. Right? It needs to have a sworn statement by the librarian. So it needs to have an attestation, basically, that's a true and correct copy of the original in his or her custody. All right. I got to throw this in here before I forget, right? Here's another example. This is how they do it in California, where they send you a summons with the complaint, right? But it doesn't have any information up here where it's for court use only, so this hasn't been in court yet. And there's no court seal on it, right? So the one in Florida had a court seal on it, but it didn't have the proper words. This is actually the proper form. It just hasn't been done properly. Right? So if they say that this is what they're using as evidence that they've summoned you, well, they haven't, because there's no court seal and there's no court information on it. Right? Now, there is court information on other documents that they filed with this guy at the same time. We're trying to find one here. Right? This has been filed or endorsed, right? It's, this is another state form, and it's been put in the Superior Court, but the summons wasn't. So, this is just more evidence of the deceit that goes on in court cases, and you got to get over it. This is what they're doing, right? You're not going to write a smarter piece of paper than they did. You're not going to cut a deal with them. You need to rebuke the devil, right? And answer and say that, hey, this wasn't done properly. Okay, so what did Carl say? He did a writ of mandamus way back in 2013. He recorded a document, and he got summons to court and for a credit card bill, right? Drake County Court, Greenville, Ohio. He mailed this to the court, the mandamus, prior to arriving, scheduled court date. When he arrived, the bailiff blocked me at the door and pushed a dismissal. Okay. Well, what did he do? Right. Well, first of all, he got it recorded, right? So this satisfied full faith and credit as far as the Constitution's concerned. So that's what he did right. He got it recorded, and then he filed that into his court case. Now, I don't know how he filed the court case. He sent it to the clerk or what. That part wasn't covered. But when he did it, he said that he was a court. Right? So it's like, okay, well, I get it now. Let's call ourselves a court. Right? Whatever it is you're going to do, get it done and, file it into the record like that, or have it attested by a notary public, and then have the notary public's, this is if you're going to send it out of state, you go get a certificate of authority for them. Right? But you wouldn't have the notary do a jurat, and you wouldn't have them do an acknowledgement. They have a thing to do, an attestation. Right? And that's what you want. It needs to be attested. And we'll look at what that is. I mean, but so here is Carl acting as a judge, right? So the judge is going to do this, and he's going to sign it with an attestation statement that says he signed it in front of an attorney, in front of a notary public. And then you go to the notary public, keeper of the records, which is usually the county clerk, and you get their certificate of authority, and you have full proof evidence that from the court of Carl said whatever Carl said. Now, in this case, Carl's saying it's a writ of mandamus. But it could also say this is a judgment against the plaintiff's attorney or whoever it is, right? It's a foreign judgment against them for malicious prosecution. That's why I want to try to use it. So I'm not going to try to read this whole thing, but I don't mind slowly, going page by page so you guys can read it. So let me just do this here, and I'll wait a few seconds and pause. Pause again if you need to. You want to read the rest of it. I don't know if any of this shit is what made a difference or not. So I'm not going to say it did or not. But the court of record of Carl Clarence III. Now I'd use my full legal name, Robert Allen Ratluski. So I'm not doing any of this stuff here. I'm not playing this game. I got to separate and make house of. I don't believe in any of that stuff. If you believe in it, go ahead and do it. Because at the end of the day, you get a notary to witness it and get it attested. They'll put it in the court case. All right, pause. 1, 2, 3, 4, 5. All right, pause again if you need to. Pause. And pause again. Sounds like going to the eye doctor. This or that. And finally, pause again. Record the following. He's got his own court seal. He wants to be the executor. Carl Clarence III, House of Schaefer. Well, if that's your name, brother, then it better be on your driver's license. That's all. That's what I'm saying. Well, that's not your identification. And I'm not an executor. I'm an owner. I own my stuff. I'm not dead. I don't need somebody to execute it for me. I'm my own court. So I don't agree with the way that, some of this stuff is done, but at the end of the day, it got his case dismissed, so I'm not going to complain. I'm just saying if you went to all this trouble now, all that's missing is to have signed it in front of the well, it looks like he did it in front of witnesses, right? But you could do it in front of a notary and then get the certificate of authority, and it would be a full proof and credit, full faith and credit. So let me show you what that looks like real quick. Hang on a second. Yeah, so when you get done with the notary, whatever it is you had them do, you can go to in Michigan, go to the county, the county clerk's office. And they can give you this thing they call a certificate of authority, which just says, the clerk is saying that the person that did it subscribed the certificate or proof of acknowledgement on the annexed instrument, and wherein written, what's the time of the inking such proof of acknowledgement, a notary public in and for said county, duly commissioned and qualified, and duly authorized take the same. So you can't see it on here, but this has got a seal right here, right? And it's the seal for the court of Montcalm County, Michigan. And this next one shows better, right? At least a little bit. This is another one from Kent County, right, where it says seal of the circuit court of Kent County, Michigan, which is really the same seal as this one here, where it says Circuit Court of Bay County, right? It's a seal of Circuit Court of Bay County. So, you get that on your paper. You just got a document from the court of, the county. And it said in there that, it has to, these all would have to be given full faith and credit under the 4th article of the Constitution. Okay, so let's say you're going to act like the court then. Well, in Michigan, they have this thing called the Uniform Enforcement of Foreign Judgment Act, where it says, as used in this act, a foreign judgment means any judgment, decree, order of a court of the United States or any other court that is entitled for full faith and credit in this state. Well, that would be the court that just put the seal on these documents from the clerk's office. Right? That seal is for the seal of the court of Circuit Court of Montcalm County or Kent County or whatever county it is, Bay County. It gets full faith and credit. A copy of a foreign judgment authenticated in accordance with the Act of Congress, and that's what you're doing by having the Notary Act authenticated, may be filed in the office of the clerk of the Circuit Court, District Court, or Municipal Court of the state. The clerk shall treat the foreign judgment in the same manner as a judgment of a circuit court, the district court, or municipal court of the state. A judgment filed as under this act has the same effect and is subject to the same procedures, defenses, proceedings for reopening, vacating, or staying as a judgment of the circuit court, district court, municipal court of the state, and may be enforced or satisfied in like manner. So it's the same as a frickin' circuit court judgment if you get it filed in the circuit court's office. So what do you have to do? You got to file an affidavit. So at the time of filing the foreign judgment, the judgment creditor or his or her attorney shall make and file a clerk of court an affidavit setting forth the name, last known address of the judgment debtor and judgment creditor, right? And then pay for it, which they got fees like $150 to have it done. Oh, shoot. Hang on a second, please. So, real quick then, well, what does it take to do this? Well, this in Wayne County, Michigan, right? Registration of a civil foreign judgment. The filing is required for persons seeking to register a monetary judgment obtained in another state for the purpose of the enforcement of a judgment. It tells you what form to use, and it says no petition complaint is necessary. Circuit court jurisdictions amount $25,000 in an excess, unless the matter is of a jurisdiction of the Grosse Pointe Municipal Court. Authenticated or certified copy of a judgment for the court file and circuit court judge to review. So you got to give them 2 copies and pay $150. So it costs you $150 to have your foreign judgment filed into the circuit court clerk's office in Wayne County, Michigan. What does that look like? Let me find this damn thing now. So, all right, so this is the form you have to put in. This is the form they're talking about. You got to have this affidavit. Then I got a place up here, state, whatever circuit it is, so forth, right? I guess you could say that. You could put that in. So what I'm not really sure is the case number, right? But, anyways, judgment creditor, judgment debtor. So you would be the creditor, and the debtor would be the attorney firm that brought the action for the plaintiff that didn't exist. You're going to say it's a malicious prosecution, right? And so that's what the judgment is, and this is the affidavit that goes on top of it. But the judgment debtor is the attorney firm. Name of state where foreign judgment was issued, name of court which issued the foreign judgment, case number, amount adjudged, date of judgment, right? Judgment creditor, attorney signature, So now I know that some people are doing their assemblies. Your assembly could do this, right? They want to be the court, then have them be the court and put in a foreign judgment. But do it against the attorney firm, right? They're the debtor, right, for bringing the claim in the first place. So I'm not even trying to tell anybody to go do this shit. I'm just pointing out this is what I'm going to try to figure out how to do, right? If you already got it figured out, then go do it and then tell me how it worked, right? But don't call me and give me a bunch of ideas, right? Go try them and see what works. I'm going to go try my own ideas. And I'll do a video on it, see if it works. But this is the thing. You fill this form out, and attached to this is the judgment that you're going to have authenticated by a notary. And you're supposed to be able to file with the clerk's office. So, it might help to go to the clerk's office and look at a foreign judgment that's been filed, see how it's been done. Right? I don't have a car, so I have a hard time getting around. But if somebody does that, if somebody could go down to their clerk's office and tell them you want to see a copy of a foreign judgment, with the affidavit, all the documents, everything, and get a copy for you and then email me a copy. So that's why I have, that's why I'm saying what I'm saying. This is, faith is Esquires' Achilles' heel. You can pray in court. That's a public act. Right? You can go file paperwork with the county recorder's office. File in a court case. Well, that's got full faith and credit. Or, you can have your own court and do a judicial proceeding. And for it to have full faith and credit, it just needs to have the notary seal been authenticated. The notary is going to attest to your signing it that it was an attestation. I need to look at that again too. I had that. It's on a notary handbook, right? Witnessing or attesting. They give you these 3 different things that notaries can do, basically. You can do an acknowledgement, administering oaths or affirmations, and witness or attest to a signature. Well, that's what we want them to do as an attestation, right? And it's going to say signed or attested before me by on the blah, blah, blah. So, put your name, what day it was, when it was. And then the rest of this is for the notary to do. And if you have this attestation at the bottom of your page, you just made the notary a witness. right? They're going to be witnessing or attesting your signature. Okay, so I hope I didn't. Yeah, it's going a little bit too long. Anyways, but over an hour. So if you're still here, thank you for sticking around. And that's what I'm working on. Along with trying some things through the Inspector General's Office of the Military. But this would be things that, if you have a foreclosure going on, right, you need to file an answer. Forget everything else I said. You never filed an answer, right? This is the thing. But you've never been served. So now it's time to file an answer in the case to go away. It may still show up on the paperwork, but, if you could believe what Jackie had to say, right? The lien's been released, the mortgage has been released, the affidavit's been released, and somebody's paying her freaking property taxes. Well, that's a pretty good deal. You should get in line. Okay, I'm going to leave it there. Y'all have a great day. See you now.